Okay, another phone call. It's on an oil deal. I didn't take it. I didn't pick it up. So I'm going to call one of these portions of this call Hell is Coming to Breakfast, after that outlaw Josie Wales movie where Chief Indian George talks to the grandmother, the Yellow Rose of Texas or something, but the grandmother from Kansas. That's where she was from. She was from Kansas. And says, get ready, hell's coming for breakfast, because they're been taken over by these bad guys. And up on the hill is Clint. And he's on a horse with a white flag. And Chief Indian George says, if I read this right, the sun's behind him. We have an edge. That's his edge. Well, I'm been a little long-winded here, but I think we've got an edge in the case of GTII for those of you who were following this as a short. Anyway, very quickly, I'm not going to read it again this time. I just want to show you. You can look it up yourself. The company released a press release on Friday. And it states that it cautions shareholders against social media misinformation, and it makes clear that there is no indication that Seth Kramer, Kurt Kramer, or any of their entities is shorting this stock. So it does point out that they entered into an agreement with Kurt Kramer and Geneva Roth Remark Holdings in a note, and it also, the weather's so nice here, but the wind is going. Anyway, what's interesting in this, it says that they closed out that note with Kurt Kramer. It emphasizes that they have no knowledge that the Kramers are manipulating their stock price or shorting their stock. I want to get this document here. Just hang on a second. That's my dog. Okay. So, they really make it clear the Kramers, there's no information that the Kramers are involved in this. But they also make clear that the Kramers released the shares that were held in reserve against their convertible note. So I was just talking to somebody on the phone, and then I just said this to this group, and so I'm repeating it for the third time, so I'm already bored with it. But what's interesting about this is in this note, which I read on the last little bit from this securities agreement, and I'm not going to even bother referencing it, other than it has this one clause where the transfer agent is given irrevocable instructions to deliver shares anywhere under that deal where Kramer wants it sent. And again, that's expired. I'm not implying anything now. So I don't see where the risk is. You sell the hell out of it and you deliver the shares. Okay, so then I wanted to tell you guys something. And that's why since the press release references this note, I just wanted to read to you, just refresh your memory. The note was issued on November 27, 2020, and it was a securities purchase agreement with Geneva Roth Remark Holdings, which has been mentioned, of a convertible promissory note. The aggregated principal amount was $74,800, which had a discount to the Kramers of $6,800, so they didn't get that much. and it had in it that GTII had to cover $3,000 of the Kramer's expenses. It doesn't exist anymore, it bore a rate of 10% per annum. And then this is what I wanted to tell you. And this is, I think this is Rule 144. You know, when you buy stocks from a publicly traded company, they cannot be registered. They have a stamp on them for 6 months. So you have to get that registration statement lifted before the stocks are free to trade. So anyway, I think that's why this says this. The promissory note may be converted at any time after 180 days, 6 months, from the issue date of the note, which was November 27, 2020, at a price equal to 75% multiplied by the market price as defined herein. It didn't really, what I'm reading doesn't say, but it's a 25% discount. The maturity date's 1 year and must be fully converted on or before maturity date in order to be converted. And then the company GTII had a right to pay that off. So then there's a little bit of a footnote on the conversion price for the, let me just put my dog inside. Okay, so here it is. Geneva Roth will be able to convert the amount of the loan with interest into shares 75% of the share price, 25% discount. The share price is determined as the average price of the 15 days leading up to the conversion date. The lower the share price is in the final 3 weeks, the more shares of the company Geneva Roth will get. Obviously, that's some interpretation by the guy that wrote this. But the point is 15 days, that's 2 weeks. So in my experience, I don't know why any company would sign this contract anyway, but most people can figure out that a market price needs to be defined. So that can be defined in many different ways, but frequently, and I assume in the fine print it might have been defined as an average of the opening price and the closing price. It could be an average between the high and the low. It could just be the closing price, but that would be defined in the contract. But you get a discount of 25%, which is massive, massive. You know, I had a client who had one of his clients call him a meathead because he was constantly and successfully generating 2 to 3% a month, driving in between a 3 to 5% spread on discounted shares, and he did it annually. But his client, who was my client too, called him a meathead because he wasn't doing anything. Imagine what he'd call this guy. He's got a 25% spread. You could drive a Mack truck down that. You just sell stock, sell stock, sell stock, sell stock, sell stock, and you have a letter in your back pocket that you can deliver to the transfer agent, deliver the shares to cover it. So you start at $5. Well, in the case, I think in the case of GTII, they started at 10 cents roughly. And I'm doing this by memory, but I think they got the stock down to half a penny. So they sold a lot of stock under the auspices of this contract. So anyway, I wanted to point that out to you. Now, we get into what might be interesting and might be our edge. The company made the press release that the Kramers are not, there's no evidence that the Kramers are shorting. And I accept that at face value. The company, however, did sign that note. So there was a period of time when the Kramers believed that they were going to be able to pull this get out of jail free card out of their pocket and cover all the shares that they sold. Well, going back to the description of my client, who I knew pretty well, being a meathead, it might be descriptive of what someone in the Kramer's office that was responsible for these sales. A meathead could just sell every day at any price, any news, during the term of the note. So just sell. Just keep selling. Just make sure you keep driving the price down or keep it below a certain level, but just sell as many as you want, because we've got, you know, this letter of transit from Rick at Rick's Cafe. So what I'm trying to say is or trying to point out is that the Geneva Roth Remark Holdings, the meathead, sold shares during the time that that was there. Well, the company just in that press release announced that they paid that off, and those shares were released back from the transfer agent. So what happens? What I think might have happened is everything's computerized now except the settlement system. Everything's computerized in our life. Except the settlement system. So what happened is the shares were released back to the company, but I have a feeling that the rumors that the short position was 35 to 50 million shares during the time of that note may be true. And I think we can figure that it was the Kramers or Geneva Roth Remark Holding selling those shares. But we actually don't know, but it's their contract, it's their conversion feature, and it's their money that they lend. So during the time that GTII owed them money, maybe they were the sellers. Let's put it that way. Well, anyway, we can agree that if there were sellers, and if the reported amount of those shares, remember it was under 10 cents a share and down to a penny a share, so it's going to be a big number, was somewhere between 30 and 50, 60 million shares. Those shares are still out there. Now they're naked short. There is no, get out of jail free card, as I said before. So, all right, so I think we can agree that to the possibility that there's 30, 40, 50, even 60 million shares outstanding from that time. I love the weather, but the wind. Anyway, I'm going to get those because that's distracting me. So again, hang on. All right, so I wanted to give you one more reason to believe that the Kramers are not involved in this selling. And I just got to find it. So I just want to put I want to join in GTII's caution that we have absolutely no evidence that the Kramers are sellers. And in fact, I think right here is a reason to say that they're not. This is an SEC finding, and it's between Kurt Kramer and the SEC. I'll read all that. This is under the Securities Act of 1933. It's release number 9485. It was released in November 25 of 2013. It was an administrative proceeding, file number 3-15621, in the matter of Kurt Kramer, Mazuma Corporation, Mazuma Funding Corporation, and Mazuma Holding Corporation. They're collectively known as the respondents, and the SEC. This is an order instituting cease and desist proceedings pursuant to Sections 8A of the Securities Act of 1933, and it makes findings, and it imposes a cease and desist order. Okay, the Commission deems it appropriate that cease and desist proceedings be and hereby are instituted pursuant to Section 8A of the Securities Act against Kurt Kramer, Mazuma Corporation, Mazuma Funding Corporation, and Mazuma Holding, the respondents. This is a legal document printed, released by the Securities and Exchange Commission of the United States of America. Okay, respondents came to the SEC with an offer of settlement, and respondents consent to the entry of this order instituting cease and desist proceedings pursuant to Section 8A of the Securities Act of 1933, making findings and imposing a cease and desist order as set forth below. Remember, they came to the SEC with us. Why would they do that? I think that, my opinion is, they don't want discovery, because all of the, while settlement is not computerized, and probably order taking isn't, all record keeping isn't computerized perhaps, all order tickets are required to be saved by brokerage firms. So there is a record of whether a ticket was marked long and they failed to deliver, whether the ticket was marked short and they failed to borrow, whether they said the ticket was a long trade but it was really a short trade. So they don't want that discovered. That's my opinion. Okay, next page. This is Section 3. On the basis of this order and the respondent's offer, the Commission finds that 1. Kurt Kramer, a resident of Glen Head, New York, is the sole officer and registered agent of those companies. See, it's number 1. And then it goes down, says more about each of those. Okay, then under number 5. 3.5. From August 2006 through January 2010, Kurt Kramer, the respondents, purchased from Laidlaw Energy Group more than $2 billion. I'll say it again, $2 billion with a B. B as in Bill. B as in a whole lot of shares. 2 billion shares they purchased. It represented 80% of Laidlaw's outstanding shares. They bought them in 35 tranches, according to this. I'm reading from this document. And they resold those shares to the public. Respondents claim to rely on an exemption from registration pursuant to Rule 504 of Regulation D. Number 6, respondents purchased the shares at a significant discount from then prevailing market prices. The discount made it highly likely that respondents could immediately resell the Laidlaw shares to the public for a short-term profit. That's slightly different than what I think happened at GTII, or it didn't. We don't know anything at GTII other than maybe it was going to happen. But at other companies where toxic notes happen, they sell the shares first at higher levels, then they convert on using a formula later on into a price decline that they themselves created. So it's slightly different, but it's the same net effect. Okay, number 7, no registration statement was filed as to any of the shares. Okay, and then it goes on. I'm not a lawyer. There's some numbers, and there's certain amounts below which you get exempt. Okay. Now we go on to number 13, 313. No registration statement was filed as to any of the Bedera shares offered and sold to Kramer and Mazuma Funding Holding, and no exemption from registration was applicable to those transactions. Number 15, as a result of the conduct described above, Kramer and the other companies violated sections 5A and 5C of the Securities Act, which prohibit the direct or indirect sale or offer for sale of securities through the mails or interstate commerce unless a registration statement has been filed or is in effect. So the respondents, that's the Kramers, have undertaken to forego directly or indirectly, including but not limited to, through any entity owned or controlled by the responsible, participating in any issuance or purchase, offer, or sale of any security made pursuant to or claiming an exemption under Rule 504 of Regulation D, 17 CFR. That's the undertaking. So then you go to Section 4, the order. It is ordered that, pursuant to Section 8A of the Securities Act, respondents cease and desist from committing or causing any violations and any future violations of Section 5A and 5C of the Securities Act. I think I'll just read that again. It is ordered that, according to Section 8A of the Securities Act, the Kramers, respondents, cease and desist from committing or causing any violations and any future violations of Sections 5A and 5C of the Securities Act. So we have pretty good indication here that they're probably not the ones selling in the case of GTII, because they signed a cease and desist order. And this was filed by the Commission and signed by Elizabeth M. Murphy, Secretary. So I think that's a pretty good argument that the Kramers are not the ones selling, because they entered into an agreement hard and fast with the SEC not to violate the Securities Act in the future. I'm not going to read it again, but as I'm reciting this to you, it seems like that agreement that they signed, the securities purchase agreement that they signed in Virginia that I just read to you, admittedly between the Blackstone Group and Sixth Sense Securities, or whatever they're called, they agree amongst themselves that there's no violation. But it'd be reasonable to ask whether that is a violation of the Securities Act. Okay, now what I want to show you. This is the Securities Act, printed out. It's a phone book size. Okay, Section 5. A. I'm going to just read the sentence, Section 5A. Unless a registration statement is in effect as to a security, it shall be unlawful for any person, directly or indirectly, 1. Communication, interstate commerce. 2. Carry or cause through the mails. Make or use any means of instrumentation of transportation, communication, carry or cause through the mails, blah, blah. Then it goes on to C. It shall be unlawful for any person, directly or indirectly, to make any use of means. I got that backwards. So permit me to start again. 5C. It shall be unlawful for any person, directly or indirectly, to make use of any means or instruments of transportation or communication in interstate commerce or of the mails to offer to sell or offer to buy through the use or medium of any prospectus or otherwise any security, unless a registration statement has been filed as to such security, or while the registration statement is the subject of a refusal order or stop order, or prior to the effective date, any public proceeding or examination under Section 8. Okay. I want to go to section, I think it's Section 8. I highlighted one more for you. And if I don't find it right away, I'm just going to move on with my point, because who wants to wait for me to find something? So my point is, the Kramers did sign a cease and desist order to not trying to find Section 8, to not commit any violation of this act, those specific provisions in the act, in the future. Well, they signed that one that I just read to you in 2013. Bill Clinton asked what the definition of is. Was that his question? Well, I wonder what the definition of in the future is. Today I'm talking to you, I think it's June 17th, 2022. That order was entered in 2013. It's after 2013. I'm still alive. The skies are brilliantly blue. So I think that's the future. And they agreed not to violate anymore. So I would say that the Kramers aren't the ones selling, because they would be violating the cease and desist order that they agreed to. Okay, Section 8 is a long thing, and it's about registration and all that. I'm not going to read it. It's just not that interesting to me right now. Okay, now I want to move on to something which is might be our edge. Might be our edge. How you doing? How you doing? That's what they say in New York. How you doing? I'm doing. I'm doing. How you doing? Well, I'm doing. Okay, I'm going to go through a couple of things here that are pretty darn interesting. I got this under securities lawyer. I wrote all over it. But it says unregistered dealer activity, not just for the SEC anymore. And let me just read the first little section of it to you. It's pretty interesting. Dated 6/1/22. And I'm reading from it right from the internet. Title, you can Google it, Unregistered Dealer Activity, Not Just for the SEC Anymore. Over the past few years, we've written frequently about so-called toxic lenders engaged in unregistered dealer activity and the toll their loans take on struggling over-the-counter companies. Nearly all of these companies need financing for operations, research and development, expansion, and more, and are rarely able to obtain it from banks or other traditional lenders. They, the companies, turn instead to the toxic funders who charge high interest and, in the end, almost always convert their notes into enormous amounts of unrestricted stock. That, or this, causes runaway dilution and damages the companies and their investors, and can result in reverse splits and even bankruptcy. So here comes our edge, which I was kind of interested to see. Since 2017, the Securities and Exchange Commission has been trying to deal with the problem by suing the lenders for acting as unregistered dealers. I just read to you all this stuff under Section 7 and Section 8 about not being registered, not having a registration agreement in place. Okay, though they've won one important victory against Ibrahim Al-Maghrabi and his company Microcap Equity Group, others are waiting in the wings, and I really hope others include people we might be talking about. Preparing and prosecuting individual lawsuits is time-consuming and expensive. The SEC has another remedy in mind, and this again goes to what's exciting, which entails changing the way note conversions work under Rule 144. Again, I think Rule 144, at least it was in my experience, it could be bigger than this, but I think all it is that you have a registration statement under this act. You can't sell those shares until 6 months pass. A newly issued public share cannot be sold for 6 months in a private transaction. Okay, the initial transaction was private. Later on, you can sell it publicly. Okay, so the other remedy is changing that rule, but it hasn't come into effect. In the meantime, issuers victimized by toxic lenders try to fight back as best they can. One such company, GTII Inc., won a significant victory when the New York State of Appeals held that GTII's lender, Otterboss, had committed criminal usury, and that the contract between lender and borrower was void ab initio. Of course, we all know what that means, to be void ab initio. I'm going to guess before the contract ever existed. I have no idea what ab initio means. Sounds like most of my dating life is void ab initio. All right. The events eventually resulting in the New York Court of Appeals decision occurred years ago. Blah, 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 blah. So here in 2015, the Gene Sis entered into an agreement that this guy, Adar Bais, would invest a total of $54,000 in 2 convertible notes. Does that sound familiar? Each for $24,000. The first note was issued on October 28, 2015, and the second would be funded 8 months later. So all Adar Bais LLC is doing is as soon as they get the phone call, they start shorting. So they're going to give Gene Sis ID their own money. They're going to give them this massive amount of $24,000 by selling stock that they don't own into the market. As soon as they have that money, maybe it's a different pocket that they have, but they have it in the bank. Money is fungible, remember. They give it to Gene Sis, and they get one of those irrevocable transfer clauses put in place, and then they have 8 months to continue selling into the open market, driving Gene Sis's stock down, because they have this letter of transit from Rick saying that they can get out of Casablanca without inspection. Okay. This is owned by a guy, doesn't matter here, and then goes on and on with all the things that happened to the stock splits, blah blah. Then there was a lawsuit from Goldstein, who's the guy, I'll give you his name, Ira Goldstein, and Adar Bais sued Gene for not holding up its end of the toxic convertible note. Okay, I'm skipping pages. So then here, the note also specified that Gene would issue irrevocable instructions to the transfer agent requiring the reservation of 278,000 shares of common stock for eventual conversion. To me, that sounds, whatever the price, that sounds like a lot of stock for an initial investment of 24 grand. Okay, so that was 278,000 shares. And then, quote, reserve a minimum of 3 times the amount of shares required if the note would be fully converted. So 6 months later, Adar Bais requested the conversion of $5,000 of debt into 439,560 shares of Gene Sis ID's common stock. The request was, as these things go, modest, considering the size of the loan. So then anyway, Gene stopped filing with the SEC, and so this was a concern. I mean, look at this prepayment that the company had. Okay, let me just read in this note. It's just incredible. If you're still with me, if you're not, I apologize. But this is just incredible that the SEC allows this. On May 24, 2016, the company entered into agreement with Goldstein to invest into the company $35,000 in exchange for a convertible promissory note. The note bears interest at the rate of 8%. All outstanding principals and interest is due and payable a year later. The note is convertible into shares of the common stock at any time after that 6 months. Remember, Reg 144 from the note. The conversion price is equal to 65%, so it's a 35% discount. You can drive a Abrams tank down this. Multiply by the lowest trading price, the lowest, not even an average, on the common stock for the previous 20 days. It's not even an average. For 20 days prior to the conversion, it's the lowest tick. It's the lowest one. It's the lowest print on 20 days of trading. So they're in there just selling. Now, bless their heart, Goldstein and his company Adar Buys has given to Gene the right to buy back this note at 115% of face within 60 days. Well, they borrowed the money because they have no money, so 60 days goes by very quickly. Or at 125% of face within 61 to 120 days, or at 135% of face within 121 days and 180 days. So in that first 6 months where they can't do anything, they have a right to buy it back. Whew. Now, you would ask, well, isn't that risky to the company if they buy it back? They've shorted to Goldstein, and I can't pronounce the company, Adar Buys. Isn't that risky? Because if they buy it back, they've shorted all these shares, so they're naked. So that's taking risks. Well, yes, I suppose so. But what they've done is they've sold so many shares, they control that destiny by selling so much. They've driven the stock price down. Anything the company wants to do in terms of buying another company, having another stock issuance, no other banker will help this company while this is in place. So they can write off traditional other sources of money. So the stock price is going down, down, down. When they get this money back from Gene, they can go in the market and buy back the shares at such a severe discount, or just leave it out there. The company is on a highway to hell. Hell is coming to breakfast. We're going to flip that. Hell is coming to breakfast for the companies that borrow from the shorts. But I think now hell is coming to breakfast for those that are left with these naked positions, whoever they are. All right, it goes on and on with all the clauses. Okay, so this guy, Adar Buys, this guy Goldstein, argued that in return for the money that he put up, total damages came to $92,000. And you remember better than I, but I think he agreed to put up 25 and 25. But anyway, I don't think he ever got to the second amount because the company didn't make its filings during the 6 months. So I think he put up 25 grand initially. Damages and everything came to 92,000. He argued that Adar Buys argued that these disputes relate to legal conclusions, not actual facts. Lawyers. Okay, so then the judge, this lower judge, I want to move on quickly. This lower judge said that New York makes provisions for two types of usury, civil and criminal. But there's no specific statutory authority for voiding a loan that violates criminal usury, because that's how G&D alleged that these loans were criminally usurious, because a corporation cannot, a company, Gene, cannot assert civil usury as a defense in litigation. So they had no choice but to go with criminal. Well, New York divides it into two. So then Goldstein argued there's no statutory authority for voiding a loan that violates criminal authority. Another world. So this created a problem for Gene. So it replied to Otterbeis, and it proposed a novel theory, which was basically that the legislator didn't mean to create two different types of usury. It was just two types underneath the civil context. So the judge remarked dryly, courts in this district routinely distinguish between two types of usury. So the judge didn't find that persuasive. And then the judge said, look, it boils down to this. Did Goldstein lend money to Gene, or did it arrange to purchase stock? That's what the judge said. And so he quoted a decision in 1992, which makes clear, if there is no loan, there can be no usury, however unconscionable the contract may be. The civil usury statute prescribes loans with an interest rate of greater than 16% annually. The criminal statute sets the limit at 25%. The judge here ruled that Gene failed to prove that Goldstein intended the loan to be usurious because Gene said Otterbeis cleverly disguised various additional charges that resulted in hidden interest rate. But the case law cited made clear that intent can only be proved if the note shows an unlawful interest rate. In this case, the stated rate was 8%, so you couldn't prove usury. And it was so far below 25% that intent wasn't implied. So for all those reasons, the court granted Otterbeis Goldstein's motion for summary judgment. So Gene appealed in 2018. But in the meantime, Gene had stopped trading its stock, so it wasn't even listed on the NASDAQ anymore. I wonder what that means for Goldstein. What's his risk? That he can't get the stock that he sold? Maybe. But what it really is, the company stopped trading, so the stock price is de minimis. Maybe he cannot effect a closing transaction, but he doesn't really want to do that anyway, because that creates a 1099. So I think what happened there is that he is happy. But in this pleading, he's arguing that caused an undue burden to him. Okay, I'm going to skip that. And then the panel went back to an ab initio, void ab initio. I find dating a lonely business because all of my dates don't show up ab initio. I haven't asked anyone. Sua sponte. That's another word in here. The second court did not arrive at a decision. Instead, the appeals panel decided sua sponte to certify two questions to the New York State Court of Appeals, which it believed was better to address this. So sua sponte. I don't know what that means. I guess that would mean if I wanted to go out with something, I would have to address my request sua sponte to their father to ask if I could have the hand of marriage of your daughter? I don't know what sua sponte. Anyway, here's the two questions. Whether a stock conversion option that permits a lender in its sole discretion to convert any outstanding balance to shares of stock at a fixed discount should be treated as interest for purpose of determining whether the transaction violates New York Penal Law 190.40, the criminal usury law. So the question is, does giving the lender the option to convert into stock at such a discount violate criminal usury laws? That's the one that they kicked upstairs to the appeals court. Now, what I find that the courts misunderstand here, everybody misunderstands, a fixed discount. That implies some sort of lower bracket in this price, but it's not, because the lender in this case can short the they can just sell the stock into oblivion, the price of the stock into oblivion. So I would argue that that's not a fixed discount. That discount can be whatever they want it to be. Okay, the second question. If interest charged on a loan is determined to be criminally usurious in New York, whether the contract is void, if one, is the contract void ab initio, like all of Bill Farron's dinner dates. So anyway, they put this up. There's an amicus brief, whatever that is. Oh, amicus brief. I think that's a amicus. It must be friend brief. So in from the bathroom window came Maxwell's silver hammer. On December 10, 2020, that's an interesting time frame, well before the court arrived at its decision, an unexpected non-party submitted an amicus curiae brief. Curious. I don't know. A note of interest. I don't know what. I wish I had been able to study Latin. Okay, the amicus was none other than Power Up Lending. Are you awake now? The amicus was none other than Power Up Lending Group Limited, run by Kurt Kramer. So Kramer interjected himself in somebody else's trading. You don't think these guys all work together and try to help each other? You don't think that these guys have if it's not a scam, they know they have a gray area of law that they can run a herd of cows through? They make money with this shit. All right. The amicus was none other than Power Up Lending Group, run by Kurt Kramer. And this unregistered dealer activity is not just for the SEC anymore, dated 6/18/22. Kramer is well known as a toxic lender himself. He and his companies have been the subject of SEC enforcement actions more than once. I'm just quoting this. In 2013, he agreed to pay $1.4 million to settle charges brought by the regulator against him and his firms, all the Mazumas. In October 2016, he settled charges brought against him in an administrative proceeding involving his receipt and subsequent sale of shares transferred to him and his company, Hope Capital, Inc., by insiders in the notorious scam. It's so notorious, I've never heard of it. Spongy Tech Delivery Systems, Inc., in 2008-2009. He still works as a lender to micro-cap companies, and so took an interest in the Otter buys Janine Sis ID litigation. Well, what's interesting is another name by Kurt Kramer, Hope Capital. what GTI probably understands, but all of you have to understand, these guys operate among LLC. It takes you $80 to set up an LLC. Kramer hoped to assist the court in determining the two questions as certified by the United States Court of Appeals for the Second Court. That's a quote from Kramer. He believed both questions should be answered in the negative. There's a word, chutzpah is one word, but there's another word that they used to use with the Greek gods. But these guys think they walk on water, that he could come in and offer advice to a court. Okay, so Kramer notes that his interest in the case arises from the fact that he is in the same business as Adler Bice. He admits it. So I appreciate, and maybe it's time for me to reiterate, that GTII announced on Friday past that GTII has no information that Kurt Kramer, Seth Kramer, or any of their entities are involved in any market manipulation or short selling of GTII stuff. And I have it under good authority that the law firm, which has been announced elsewhere, that was hired by the Kramers, Gibson Dunn, big law firm, has contacted at least one shareholder, maybe more, to tell them that the Kramers have nothing to do with GTII, any of this activity. By the way, this is a footnote, remember, to why I think hell is coming to breakfast for anyone that's still naked this stock. Okay, so Kramer admits he's in the same business as Goldstein, Adler Bice. He seeks to convince the court that the business isn't without considerable risk. How he can say that without gagging, I think either his definition of considerable is different than Webster's, or his definition of risk is so tight, you can't rub two dimes together. The space between the risk he's willing to take, yet the risk, the destruction he's willing to put on people's lives. Company after company, Laidlaw Energy, what happened to it? This company, Venu, what's happening to it? GTII went through trouble. We're yet to see how the story ends. But Kramer notes that he's in the same business as Adler Bice. Well, I'm not going to flip that through, but I just read it. Adler Bice has put a toxic note out to this company to destroy, which will in fact destroy the company. So how this poor soul, this poor guy, Kramer, is taking considerable risk when he's writing a contract that says to the transfer agent, issue this letter of transit immediately. I have sold billions of shares, as in the case of Laidlaw Energy. I've put my ass on the line here by selling shares that don't exist. The only way I can get them to exist is if you honor this irrevocable letter. So deliver those shares. Well, the company signed it. So it happens. So where's the risk in that? In the meantime, he's driven in the case of this poor, pitiful, I forgot about it, the Aparo County, Denver's company, black Stone Enterprises Group or something that I just told you about, the stock is 0.0025. How much lower can it go? How much risk is Kramer taking? He's sold that down, and he has that way out, that get out clause, and he's moved the jurisdiction to Virginia, I guess, because New York has found out that that's usurious, and he wants to find a new place to do business. And by the way, maybe the reason he's having Gibson Dunn contact everyone and say we're out of that GTI deal is because GTII is under New York, maybe, and so therefore the SEC has been informed. FINRA's been informed. We want arm's distance so we can continue going to these hicks down in Virginia. Well, we just found out that Virginia is a very advanced state. It happens to be where I went to school, spent a lot of time. A lot of smart people. Look at the judgment that just happened in the Depp Heard case. Virginia is a kick-ass state, so I think he's going to find out that might hurt. So anyway, he explains the potential problems raised by Rule 144 compliance. A buyer of a convertible note must wait at least 6 months before converting it into shares he's able to sell on the open market. Okay, so now he's being the honest guy, saying I'm going to hold these shares until I'm able to sell them. I've got a bridge in Arizona that used to be in London. I'll sell to you. I mean, this guy is selling this stock. He bridges this problem by selling stock before the 6 months are up. He sold stock before he even issued the note, in my opinion. Lent the money. So, boo-hoo-hoo, he's taking risk. Well, I don't want to say he's lying. I don't want to say he's prevaricating. I don't want to say he's unintelligent. But I think arguing that there's risk because he has to wait 6 months to sell flies in the face of the fact that in these cases they have these huge failed to deliver positions that they sold awaiting the application of the irrevocable issuance of stock. This makes no sense. It's not a tautology, but these are horses pulling the cart in two different directions. Okay, then the second thing. He goes on to say that the company could be delinquent, trading in the stock could be halted, but he's already sold the stock, so I don't know how that hurts him. He's already sold the stock. I guess he's implying that by waiting 6 months, he might not be able to liquidate the stocks. He's outsmarting. I mean, he's like one of these, guys, psychopaths or something. He's outsmarting the SEC, but then he's arguing that he's taking that same risk. He's already sold the stock, so none of this applies. All right, then it says here he tries to make several original points. He argues that interest is simply the cost of having the use of other people's money for a specified period. That is in quotes from Kurt Kramer. But if the note holder chooses to convert, the entity that sold the note, this is Gene Sys ID, and remember that's Goldstein, not Kurt. This is Kurt's curious brief, sold by Fruit of the Loom. No longer has the use of the note holder's money. He gets to keep the money as part of the conversion process. So what he's saying is the lender decides to convert Goldstein. Gene gets to keep the money. So he no longer has use of the note holder's money, although it originally was the note holder's money, because I guess in lieu of the money, he's converted all these gazillions worth of shares. Kramer's second original point is that or this is the second point that goes up to the top, is that Gene's contentions fail to take into account the difference in value between restricted and unrestricted stock. When did stock being restricted stop Kurt Kramer or Goldstein, as he admits they're the same business? They sell unrestricted stock. They sell restricted stock. They sell stock that doesn't exist. They create stock out of thin air. They created under these conversion features with these notes so they can tell the transfer agent, we're going to get money from the company, so don't dox us. Don't put us in the penalty box. Let us keep selling. We've always been good to you. We're going to give the market maker all this money. We're going to create. Let me just tell you what happens. In the case where they're borrowing shares from the prime broker, which I'm starting to think they don't borrow that many, but to the extent they borrow shares from the prime broker, they have to put $2.50 up per share with a prime broker. That's in a lockbox. It's their money once they deliver shares, but in the meantime, the prime broker has use of that money. Secondly, they pay a fee. It can be a lot of money. It could be 5 cents a share. It could be a lot more, depending on how hard the shares are to buy. It costs money, and they pay the market maker commission, and they're going to pay the prime broker probably $40,000-$50,000 a month just to hold the accounts. So they're paying when it's short. But I think what's happening here is the second thing. They're selling these shares long. They're mismarking these trades. They're saying they're long. They're failing to deliver. They're asking for time. They're saying, oh, we expect to get the shares in a week. Then they ask for more time. Then they ask for more time. And when it gets really hot, they show the contract to the prime broker and say, we're going to have it in 6 months. And so the prime broker says, okay, we'll wait. You never burned us before. Well, what's in it for the prime broker? The prime broker is sitting on $10 million worth of cash. There used to be a term when I was a broker, and it's skipping my mind right now, but it's unrestricted cash. It doesn't have to go into an interest-bearing account. It doesn't have to, it's a credit to the firm that the firm can use any way it wants, and they lever it up. So the prime broker gets a benefit from looking the other way on a failed to deliver, because they know it's coming in 6 months. The market maker gets millions of shares at a penny, 3 pennies. It's a lot of money. And then if the prime broker has shorted the stock, or any company that has lent shares, get the fees, and the prime broker gets monthly fees. Kramer gets to short the stock into nothingness, and when he settles up, he's got a big payday. If he just takes the money out of the LLC, there's no closing transaction, so he doesn't have to pay the IRS. He can say, "Oh, I will once there's a closing transaction." How do I know there's still risk? I wish people like Elizabeth Warren, who wrote a book about how credit cards, it's a great business plan. I won't bore you with that. She's right. They create money out of thin air, charge fees. Look at Capital One's, they give you $250. They charge $60 for the first year, $60 to process your application, charge you 24%, and then they send you another one and another one in the mail. That money's created out of thin air. And Elizabeth Warren's point was, when you earn 7% on your money, it doubles every 10 years. She said, can you see the credit card's business plan? By charging you 23% per annum, charging all these fees, creating money out of thin air, doing it in a law of large numbers way, what risk are they really taking? That's a hell of a business plan. This is a hell of a business plan. All right, now I'm coming to, hell is coming to breakfast. New York State Court of Appeals decided in favor of GTII. All right, I'm just going to skip that. That's a long paragraph, and I know you're getting tired. And then it basically, it said that it answered the second question, that it is criminal usury. So then it turned, if the first one was, so it turned to the first. And that's the question of whether this allows a lender to convert at a fixed discount to the market price should be treated as interest. And you can see how long the whole thing is, blah, 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 blah. So it goes to, and then there's more. I'm just going to go to this, what I underlined. The previous court had asked, does stock conversion options, should they be considered when determining the interest charged on a loan? And therefore usurious loans to corporations and are wholly void under the general obligations law. In conclusion, the Court of Appeals answered both questions in the affirmative. In other words, the contract doesn't exist. Before Kramer asked the girl out, there was no date, and so the steak dinner he ordered and the bottle of wine is on him. He's in trouble. I can't make that analogy run. All right, so she goes on. This is Brenda Hamilton, securities attorney in Boca Raton, Florida. She goes on to say, many lenders to microcap companies expect 45 or even 50%. And then she talks about the New York decision. The New York decision is just one more in a series of problems that have arisen in recent years for the toxic funders who have been so active and have profited so greatly in the penny stock markets. For several years now, the SEC has been taking them down for acting as unregistered dealers, as we noted above. The proposed changes in Rule 144 will wreak havoc. That's hell coming to breakfast. And now they have potential usury violations to deal with. Some of these lenders have turned to pipe deals with convertible notes and lower tier NASDAQ companies, not OTC issuers. But the golden goose seems to be on her last legs. And that is Brenda, just in case you can take a picture, Brenda in Boca Raton, securitieslawyers101.com. So anyway, that's pretty interesting. Okay. I'm going to freeze this one here. I want to tell you about one other reason that the SEC is might be our safe savior is the wrong word, but might be on the right path. And I just want to finish this all by repeating that the Kramers, according to the company, and according to, at least this is hearsay, but I understand that Gibson Dunn contacted one shareholder. So according to Gibson Dunn, through that third-party information I have, the Kramers are not involved in short selling GTII. There is not a 100 to 150 million share naked short position caused by the Kramers. There's no evidence of that. I would submit to you that there probably the Kramers did sell shares because that's their pattern of behavior, and or I should say they may have, under that letter of transit they had from the transfer agent, the irrevocable delivery of shares. So to the extent that they lent about 80 grand, a lot of it was discounted and return of fees. They lent probably 50 grand, who knows? But 50 grand at 0.05 cents a share, it's a lot of shares that they probably sold, but on the way down from 10 cents or whatever the stock was. So I think that there is a possibility that there's 30 to 40 to 50 million shares that had been sold under the auspices of that contract. The company has put out a press release that there are some things they found that don't look right. We don't have that number, but it kind of confirms that maybe there was something there. In the meantime, somebody has been selling on the, you can find it under FINRA's own data. Somebody has been selling 1, 2, 3 million shares a month. This past 30 days, they sold 1.3 million shares under the Reg Show exemption. It's there. And there's no covering that's happened. There's been no issuance of new shares by the company that are available for sale. They've issued some shares to some of the companies they incubate, but those companies want to come back out as public. So what they do is give those shares back to GTI to become their own public entity. As far as I know, there's no insider selling. In fact, the only insider that matters is David Reichman, and he's been buying stock. So he just announced another 10,000 shares he bought a week ago. So somebody's selling those shares, and for lack of a better word, they're being sold naked short. They're failed to deliver shares. Well, if it's not the Kramers, who is it? An idiot. It's an idiot. As Hamster points out over and over again, when GME and AMC were meme stocks, which is what the press is going to say this is eventually, but when they were meme stocks, they were driven down from much higher prices. I don't remember each stock, but I think it was AME. Anyway, it might have been. They were driven from $40 down to $5 or lower. GME was. I don't remember the numbers, but it went into the hundreds. But my point is, they sell them down from $40 down to $1 or down to $5. This stock, anybody here that is selling GTII over the last 18 months, their average price might be $1. It's probably less. It's probably 75 cents. Over 18 months, the stock was not that high, but as the stock price went up, they didn't sell as many shares. They sold more when it was down. They're trying to keep the stock down. So let's just say it's an average of $1. I'm gonna just assume, for the sake of my talking to you, that they sold 25 million shares. That's in between. That's probably low. At an average of $1, which I think's high, but that's $25 million over 18 months. I'm going to assume they didn't borrow any shares. They did it all long marked wrong sales. So I don't think the cost to carry is massive, but it exists. It's probably $50,000 to $100,000 a month to the prime broker. It's all the commission on the sales. So let's say they sold 25 million shares, and they paid for various costs 5 cents a share. So that's 2.5 million, and it's 1.125 million they paid in commission. And then let's say they paid $100 a month. That's 1.8 million. Let's just call that also 1.125. So call it 2.5 million. That's been a cost to carry that we can calculate. That brings the 25 million down to 22.5. The stock is underwater. If you use $1, the stock is down 25 cents a share. So it's down 50 million, $60 million, 62.5. They lost that they have because the stock's up compared to their break even. What does it cost them to borrow that money or to put that money up? I don't know. Let's assume they're not borrowing it, they're just putting it up. That's money at risk. So okay, a real short, a guy that does this for a living, or a woman does this for a living, has sold 25 million shares. They may have 25 million in their bank. They're underwater, $60 million. They have 22.5 million in the bank. They have some ongoing costs of 50 to 100,000 a month, and they're in a stock that's at $1.25, seems to be going up, seems to be surviving. What's their way out? Their way out is the stock goes to zero, it goes to bankruptcy. So what's the most they can make is $22 million. What's the risk they have on that 25 million shares? Right now they're down 60 million. I'm starting to think I'm wrong on that number. It's 25 million shares times 50 cents. Yeah, I'm probably high on that number, but anyway, they're down 12.5 million. But their risk is, if it goes back to where the stock was trading just a month ago, $1.70, they're down as much as I'm saying. What if the stock goes to 5 or 10 or 100? Their risk reward is in exchange, and I apologize for the bad arithmetic. That's because I use a calculator. But the point is, they're losing money on the trade. Would they continue to commit capital to this trade? They have so many other options out there. They could have shorted Netflix. They could be shorting the market. They could be creating stock out of thin air for Redbox, which I'll leave you with. Okay, so my point is, there is nobody that would do this trade that's a legitimate short seller. The most they can make is $1 on the downside, and they've got unlimited risk on the upside. You'd say, well, they're still going to do it. They're protecting their... Really? They'd walk away from this. Cover this trade. The Kramer should have covered this trade. I'm talking too long, but I'll finish. The Kramer should have covered this trade as quickly, and maybe they did. Maybe it's somebody else that's doing all this selling. The Kramer should have... Hubris is the word I was trying to think of. There's so much hubris surrounding the Kramers. They walk on water. they've got this orchestrated, and they've got lawyers, and they've got everything set on automatic. They think they can get away, if they are the ones selling now, because they used to be able to just go to the transfer agent and say, deliver the shares. Now they think, and there's a phone call out there in the internets, that they can call the company and rescue the company, because this company's going to be in such a dire situation, like all these poor, pitiful companies. They'll give money to buy shares, and they walk away. And worst case, they make a settlement with the SEC. In my next video, I'm going to talk about that maybe the SEC isn't such a pushover anymore, but they're going to make a settlement with the SEC that hides everything. And that's okay. So now I want to tell you why hell is coming for breakfast. I think, and it's not just my idea, talking with a couple of other people in GTII, reportedly, and I'm not making it up, it's been released, Kramer's et al., whatever LLC, whatever entity, hired Gibson Dunn. And Gibson Dunn is notifying at least one investor that I know of that they're not involved. Okay, but why would they be doing this? It's possible what's happening is there recently this the Ham27 put up on Twitter, and by the way, go to Twitter, put in $GTII, follow it. Every afternoon at 3:40 he has a conference call, and the number's there. So maybe what they're doing is getting away from GTII because they know hell is coming for breakfast, and they don't want to be there. So they're going to put it in some other LLC, some other poor schlub, and they're going to be able to continue down in Virginia or in some other place. Remember, everyone in New York thinks down south everyone is dumb. They voted for Trump. Well, they're going to get another thing coming. The South is full of really smart people. Anyway, so what might be happening is that the Kramers are distancing themselves from GTII. They want to wash their hands of it. They want to carry on their, system of creating convertible notes that have toxic conversion features in it. But in the document, it says to the borrower, you acknowledge that I'm not breaking the law and I haven't violated Securities Act of 1933. Hey, good for me. Good enough for me. So that's one leg in the hell is coming for dinner, because if they disappear, you've got 100 to 150 million shares that have failed to deliver their phantom for whatever reason, for whomever sold them, that have to be bought back. I mean, there's real shares there, but the lack of concern on the selling side is going to be turning into, I don't care what you pay, just close the trade, buy. And so you're going to see prices that you've never seen before. On that note, hour and 28 seconds, I want to say very quickly, Hamster's idea of Redbook, he gave that idea, I didn't invest in it, of I think it was AMC, when it was 164% owned versus the public float by institution. He gave that idea at $4, and you had to wait. But that damn, oh no, it was GME. That stock went to the frickin' moon. Well, RDBX is 420% owned by institutions versus the public float. So I cannot recommend that you buy GTII. I do not recommend that you buy GTII. All of this is just me talking about this as a point of interest. And I do not recommend that you buy a Redbox. But if you do hypothetically do that, put in GTC orders, and on the Redbox, 400, man, that could go to hundreds, $1,000 in a spike. Don't get greedy. Just, leave something on the table for the next guy. But I don't know. Buy 100 shares of Redbox, and it goes to 100. That pays for a trip somewhere. Anyway, that's my report. And the air conditioner just went off. I wish it had been off all this time. I'm going to try to do one more for you on another reason why hell is coming to breakfast. Clint Eastwood said in Unforgiven that he always got lucky in the draw. When he was asked, who did you kill first? He always got lucky in the draw. Well, I hope it's our turn for luck in the draw. And I wish you all the best, and cheers.